That's true.
Take it away, David.
Good morning, everyone. Welcome to the first MCLE of this calendar year. And it is my pleasure to introduce our two distinguished panelists, both of whom are on the board of the Labor and Employment section of the Contra Costa County Bar Association. Jody Yudien is a graduate of Cornell University and Washington University Law School. He's maintained a practice in Walnut Creek for 35 years. He represents businesses big and small, and he has a diverse practice with special emphasis in the area of business litigation, real estate, labor, and employment law. And he's also reluctant to get his hair cut for some reason. And Jody's going to talk to us about recent employment cases of note. Probably going to talk to us about 12 or 13 cases today, but has a list of many, many more that will be distributed, as Ann said. Marta is the Marta Vanegas is the immediate past president of the Labor and Employment Law section, and is still on the board, and is also on the CCCBA big board. Marta is a native of Budapest, Hungary, and has about 250 degrees from colleges and law schools in Hungary and the United States. And I can't pronounce where she went to school in Hungary because the school has 47 letters in it. But Marta, who is proficient fluent in Hungarian and proficient in Spanish, also has a practice in both employment law and business law, and has an office in Walnut Creek. So with that introduction, let's turn it over to Jody to tell us about cases that we should know about.
Thank you. Good morning, everybody. This group, I guess, got me to do what only a few judges have gotten me to do over the past year. That's put on a tie and a shirt. Anyway, you'll be getting a list as David said. I think there's about 37 or 38 cases with a sentence or two synopsis of each case. That'll be distributed. What I tried to do was cull from that list about 10 or 15 cases. What I did was pull cases that are either California Supreme Court cases or cases for which the Supreme Court has granted review, and as well as US Supreme Court cases. And I think in one case I pulled a Ninth Circuit en banc case. And anyway, let me go through the list. I'm going to go into some like a little law school briefing of the cases, what the facts are, what the courts decide and why they decided. The first case, and I can't pronounce it, it's Frilken versus Apple, and that's 8 Cal. All of these are obviously 2020 cases. This is 8 Cal 5th, 1038. The facts of the case are that Apple required its retail employees to go through exit searches when they would leave work. They had their bags, packages, backpacks, briefcases inspected for loss prevention after they clocked out. They were also required to have their Apple products, such as iPhones and iPads, inspected before leaving work. These searches took up to 45 minutes to complete, and they brought a class action alleging that Apple failed to pay them minimum wage and overtime wages for the time spent in these exit searches. The California Supreme Court held that the employees were entitled to be compensated for the exit searches. The court looked at the applicable wage order and the definition of hours worked, was when employees are subject to the control of the employer or when the employee is suffered or permitted to work. The court was able to decide the case without dealing with the suffered or permitted. They just focused on the control prong, and they noted that Apple controls its employees in several ways: by requiring the bag searches under the threat of discipline, by confining the employees to the company premises while they waited and underwent the exit searches. They also found that the searches were performed for Apple's benefit, which further established control. They rejected arguments made by Apple that that the employees could avoid the searches by not bringing bags or their Apple products into work. And the court rejected that. They said, as a practical matter, the searches could not be avoided. The employees had little choice but to bring a bag with them because they were required to wear their Apple clothing inside work, and then they had to change into their street clothing outside of work. Okay, the next case is Grand versus Eisenhower Medical Center, 44 Calap 5th, 1147. And I'm picking that case because California Supreme Court review has been granted. In this case, FlexCare was a temporary staffing agency. They assigned employees such as nurses to work at Eisenhower. An employee worked at Eisenhower for 8 days, and after her assignment ended, she became a named plaintiff in a class action lawsuit against FlexCare, brought on behalf of FlexCare employees assigned to hospitals throughout California. She alleged standard wage and hour claims, including unpaid overtime, meal and rest break claims. The FlexCare settled the class action case, and the named employee executed a release, which included standard language releasing the named defendant and their subsidiaries, affiliates, divisions, parent companies. They did not, the release did not release Eisenhower or the category of FlexCare's clients. So what did the employee do? She turned around and brought another class action, this time against Eisenhower, based on the same labor wage and hour violations, but on behalf of all nurses of any staffing agency employed and assigned to work at Eisenhower. Eisenhower sought indemnification from FlexCare, so FlexCare intervened into the Eisenhower class action and argued that the judgment in the FlexCare class action precluded employee claims against Eisenhower on res judicata grounds, and that Eisenhower was a released party under the FlexCare settlement. The trial court ruled against FlexCare on both grounds. FlexCare appealed, and Eisenhower filed a petition for writ of mandate. On appeal, the Court of Appeals affirmed. They found that res judicata did not bar the employee claims against Eisenhower because Eisenhower and FlexCare were not in privity. The fact that they were alleged to be jointly and severally liable and joint employers, and that FlexCare was required to indemnify Eisenhower was not enough to satisfy the privity requirements of res judicata. The court, there's another case called Castillo versus Glen 23 Calap 5th, 262. That case held that the staffing agency and their client were in privity. The court in Grande declined to follow that. The court also held that Eisenhower was not a released party under the FlexCare settlement because Eisenhower was not identified as a released party, and the agreement did not include language identifying clients, joint employers, joint obligors, or other similar language within the definition of released parties. So Unlike the Castillo case that I mentioned a minute ago, where the court held that the client was an agent of the staffing agency and fell within the scope of the release, this court declined to follow that. So again, that case is up on review by the California Supremes. Next is
Jody,
Yes.
do you want to share your screen maybe?
Oh, yeah, I'm sorry. Let me figure out how to do that. Thank you for telling me. Okay, I did this before and I figured it out on the first try. Okay, is that up now? Can you see this now? David?
Yeah,
Yeah.
but I also see
The red lines.
the red line, yeah,
Redlined.
on the bottom of the screen.
I don't see what you're talking about.
Save it as a PDF and then bring it up. Or
Yeah,
actually,
this is a PDF.
Okay.
All right.
Let me see if I can bring it up.
Should I wait?
No, go ahead. Keep talking and just scroll to where you are and then I'll let you know.
And if you bring it up, then you will have to move it along. So do you want me to bring mine up?
Well, let me just move on because I don't have a lot of time here. So the next case is Rizzo versus Jovino, Ninth Circuit case, 950 F 3rd 1217. I'm citing this case just because it was an on-bank decision. In this case, Fresno County set its employee salaries, new employee salaries based on a pay scale that had 12 levels and several steps within each level. To calculate a new employee's pay, the county started with the employee's prior pay, increased that pay by 5%, and then placed the employee in the corresponding step on the pay scale. Rizzo, a female employee, learned that a newly hired male employee with similar job title had a starting pay that's significantly more than hers, and she was earning after 3 years for the county. Rizzo sued for violation of the Equal Pay Act and sex discrimination. The county sought summary judgment, arguing that the pay disparity between Rizzo and male counterparts was the result of its policy to base pay on the employee's prior pay. It argued that prior pay was a factor other than sex that defeated Rizzo's equal pay claim. The Ninth Circuit panel held that it was bound by a case called Kuba, K-O-U-B-A versus Allstate, 691 F 2nd 873, which held that the EPA does not impose a strict prohibition against use of prior salary, so long as employees so long as the employer considers prior pay reasonably to advance an acceptable business reason. An on-bank panel of the Ninth Circuit then overruled the Kuba decision and held that prior pay can never serve as a basis for unequal pay under the EPA. They said there are 4 exceptions to the Equal Pay Act's equal pay mandate. These are 1, payments made pursuant to a seniority system; 2, merit system; 3, a system which measures earnings based on quantity or quality of production; or 4, a differential based on any factor other than sex. The court found that the factor other than sex exception must be rooted in legitimate differences in responsibilities or qualifications for jobs.
Jody,
Because
Jody,
yes,
could you move your screen so it's on the case that you're talking about till we get this figured out?
what I'm looking at it is.
What are you talking? Which one are you
Number
talking about? We can only see
Rizzo
Omen and
versus-
Conyer.
Okay, I don't know what you're looking at here. Let me get rid of this. Uh-oh. Now what do you see?
What,
I'm going to
same thing.
stop
Why
the
don't you
share.
Same
unshare your
thing.
screen quickly? And let's try it and then take a minute and open up the document that you need on your screen. There
we
we
now?
go.
Ah,
Excellent. Thank you, Jody.
Well, thanks for telling me. I mean, on my screen, it looked like I had the right thing. So that's good.
We're good. There's Rizzo. There we go. Excellent. Okay.
Okay, so that completed Rizzo. The next case, Scalia versus Employer Solutions, 951 F 3rd, 1097. That one has a petition for certiorari is pending. I have no idea if it's going to get granted, but for that reason, I picked this case. So in that case, Employer Solutions was, this is another staffing company case. They were a staffing company that recruited employees and contracted with other companies to then place those recruits at job sites belonging to third parties. Employer Solutions is ESSG, also handled administrative tasks such as payroll processing. ESSG contracted with Sync Staffing to place recruited employees at a job site run by TBG Logistics. Sorry for all the initials. From 2012 to 2014, TBG sent payroll spreadsheets to Sync Staffing, which then forwarded them to ESSG for payroll processing. ESSG's payroll processing for TBG was handled by a single ESSG employee who initially processed the payroll sheets correctly. However, a Sync Staffing employee later told the ESSG employee to process all TBG logistics hours as regular hours instead of overtime. The ESSG employee did this even though the Sync Staffing employee offered no explanation, and she knew that the employees were not being paid overtime, and she was trained on overtime requirements under the Fair Labor Standards Act. In 2016, the Secretary of Labor sued ESSG, Sync Staffing, and TBG, and another company, ESSG, complained against the other defendants for contribution or indemnification. The district court dismissed the claims, and the Ninth Circuit affirmed, holding that the Fair Labor Standards Act does not provide employees with a right to with a right to contribution or indemnification. Because the Fair Labor Standards Act does not expressly provide a right to contribution or indemnification, the Ninth Circuit considered 4 factors set forth in a case called Northwest Airlines versus Transport Workers Union, 451 U.S. 77, to determine if a right to contribution existed by implication. Applying these 4 factors, the court said the factor 1, the Fair Labor Standards Act says nothing about a right to contribution or indemnification. Number 2, the statutory scheme of the FLSA resembles the Equal Pay Act and Title VII, neither of which provide an implied right of contribution for employers. 3, the FLCA provides comprehensive statutory remedies. And 4, FLSA's legislative history provides no indication that Congress intended to create a right to a contribution or indemnification for employers. Court also said there was no implied right under federal common law. Anyway, so you have two cases now, these staffing agency cases where one employer essentially got screwed by another employer. And the bottom line, if you are representing employers and there's staffing agencies involved or multiple levels of employers, you really got to be careful when you're, in terms of either settlement agreements or what your relationships are with these with these other entities, because any one employer is going to get stuck for the screw up of another employer. Okay, the next case is Kim versus Rains International, California, 9 Cal 5th, 73. So there's a California Supreme Court case. Plaintiff was a training manager for Rains at one of its restaurants. Plaintiff and the other training managers were classified as exempt. The plaintiff sued as an individual and as a class representative under PAGA, claiming he and the other training managers had been misclassified as exempt. The employer, Rains, moved to compel arbitration of the individual claims pursuant to an enforceable arbitration agreement. The motion was granted at the trial court, and Rains then settled with the employer on his individual claim only for $20,000. Rains then moved for summary adjudication of the PAGA claim on the ground that the plaintiff lacked standing, reasoning that the plaintiff's rights had been completely redressed by the settlement of his individual claims. At the trial court level, the court said the plaintiff was no longer an aggrieved employee and lacked PAGA standing, and the Court of Appeal affirmed. Then the California Supreme Court reversed. The court explained that the plain language of Labor Code 2699C has only 2 requirements for standing as an aggrieved employee under PAGA. The plaintiff must be someone who is employed by the alleged violator, and the plaintiff must be one against whom one or more of the alleged violations was committed. The court reasoned that plaintiff became an aggrieved employee when one or more labor code violations were committed against him, and the payment of the individual remedies did not nullify these violations. PAGA standing is not premised on or linked to the continued existence of an employee's injury. Next case, Betancourt versus OS Restaurant Services, LLC, 49 Calap 5th, 240. Again, let me move this. Again, this is a case in which the Supreme Court has granted review. In this case, the plaintiff sued for failure to provide rest breaks and meal periods, and for whistleblower retaliation and wrongful termination. He prayed for, among other forms of relief, unpaid premium wages for meal and rest break violations, penalties, costs, attorney's fees, and waiting time penalties. The parties settled with monetary relief for the failure to provide meal and rest periods and failure to provide accurate itemized wage statements and waiting time penalties. And they agreed to litigate the sole issue of whether plaintiff was entitled to recover attorney's fees based on her wage and hour claims. Plaintiff filed a motion for attorney's fees and prevailed in the trial court. The Court of Appeal reversed. The court first noted that under California Supreme Court decision in Kirby versus Immoose Fire Protection, 53 Cal 4th, 1244, a plaintiff could not obtain attorney's fees based solely on her claims for non-provision of meal or rest breaks, because such an action is not brought for non-payment of wages within the meaning of Labor Code Section 218.5. The court then held that by extension, the plaintiff was similarly could not recover penalties or attorney's fees for derivative waiting time and wage statement violations based upon the same claims of non-provision of meal and rest periods. As I said, this is up before the Supreme Court for review. Also, about a year ago, the California Supreme Court granted review on a case called Narang. I'm probably going to screw up the pronunciation. I think it's Naranjo versus Spectrum Security Services, 257 Cal Reporter 3rd, 188. That case is pending on the same issue, whether violation of the meal and rest break clause gives rise to derivative claims for waiting time and wage statement penalties. So keep an eye, those are going to be, I think, big cases when they finally get decided. Next case made the big news over the summer. Bostock versus Clayton County, a U.S. Supreme Court case. Official site is not available, but the unofficial sites are 140 S Court 1731 and 207 Lawyers Edition 2nd 218. In that case, the court held that Title VII prohibits employers from discriminating against employees on the basis of sexual orientation or gender identity. Just a little bit of the reasoning by the court. They explain that Title VII creates a but-for causation standard to determine whether an employer violates the statute, and that under this statute, an employee invariably considers an employee's sex when it discriminates based on sexual orientation or gender identity. Justice Gorsuch gave an example, said a hypothetical in which an employer has a policy of firing all gay and lesbian employees. If an employee brings a female spouse to a holiday party, the employer's decision whether to fire that employee under the employer's policy will depend entirely on whether the employee is a man or a woman. If the employee is a man, he won't be fired, but if the employee is a woman, she will be fired. So under that logic, the sex of the employee was the but-for causation. The court rejected the argument that if words are given their conversational use, someone fired based on their sexual orientation or gender identity would not say they were fired because of sex. The court explained that conversational conventions do not control Title VII legal analysis, which makes sense. The court also explained the court rejected the argument that the drafters did not envision laws to cover sexual orientation and gender identity discrimination. In response to concerns that Title VII may conflict with an employer's religious convictions, the court responded that the First Amendment, specifically the ministerial exception and the Religious Freedom Restoration Act, may provide a defense to employers in some cases, but the court explicitly reserved those religious liberty questions for future cases. The next two cases are going to be really long. Sorry about that, but these are cases that both came down from the California Supreme Court. Both of them were actually certified questions from the Ninth Circuit, and then the Supremes addressed these and gave very lengthy opinions. The first case is Ward versus United Airlines, 9 Cal 5th, 732. The Ward case started as 3 separate class actions brought in California State Court against United Airlines by a pilot and 2 flight attendants. All 3 members alleged that United's wage statements failed to satisfy Labor Code Section 226 wage statement requirements. The Ninth Circuit asked the California Supreme Court to address 2 questions. Question one, they said that wage order number 9 exempts from its wage statement requirements an employee who has entered into a collective bargaining under the Railway Labor Act. And just so you understand, even though these are airlines, the airlines are not covered. The airlines, like railroads, are covered by the Railway Labor Act, not the National Labor Relations Act. Again, there's an exception for Railway Labor Act employees from the wage statement requirements of wage order number 9. The question that the Ninth Circuit had for the California Supreme Court is, does the Railway Labor Act exemption in wage order 9 bar a wage statement claim brought under Labor Code Section 226 by an employee who is covered by a collective bargaining agreement? The answer that came back on that was no. The court reasoned that Labor Code Section 226 requires employers to provide employees semi-monthly or at the time of each payment with a written wage statement containing specific pieces of information. Wage Order 9, which applies to workers in the transportation industry, sets out certain wage statement requirements that overlap with, but are narrower, can't even say the word, now more narrow than the requirements of Section 226. Exempt from the wage orders requirements are employees who have entered into a collective bargaining agreement under and accordance with the provisions of the Railway Labor Act. The plaintiff crew members were all parties to a collective bargaining agreement entered in accordance with the RLA. And while it is undisputed that United does not have to comply with these wage statement requirements of the wage order, United argued that the exemption from wage order should similarly apply to Labor Code 226. The Supreme Court rejected the argument, and they explained that Section 226, by its plain terms, contains no such exemption, and that there is no basis in the statutory language or legislative history for inferring such an exception. The second question the Ninth Circuit posed was, does Section 226 apply to wage statements provided by an out-of-state employer to an employee who resides in California, receives pay in California, and pays California income tax on his or her wages, but who does not work principally in California or in any other state? And the answer that came back from the Supreme Court was maybe. The California Supreme Court explained that when it comes to the regulation of interstate employment, the question that needs to be asked is what kind of California connections will suffice to trigger the relevant provisions of California law. The connections that suffice for purposes of one statute may not suffice for purposes of another statute. The court says there is no single all-purpose answer to the question of when state law will apply to an interstate employment relationship or a set of interstate transactions. The court then specifically addressed the kinds of California connections that are necessary to trigger Labor Code 226, and they declined to put any weight on factors such as residence of the employee, location of the employer, location of received wages, or location where taxes are paid. Instead, the court focused on whether the employee's principal place of work is in California. The court explained that the legislature intended for 226 to apply to workers whose work is not performed predominantly in any one state, provided that California is the state that has the most significant relationship to the work. For interstate transportation workers and others who do not work more than half their time in any one state, the court concluded that this principle will be satisfied if the worker performs some work in California and is based in California, meaning that California serves as the physical location where the worker presents himself or herself to begin work. The question whether 226 applies is twofold. So first, you need to consider whether the employee works more than half of his or her time in any one state. If the answer is yes, and if that state is California, then Section 226 applies. If the answer is yes, and that state is not California, so if the employee works more than half of his or her time in another state, then Section 226 does not apply. Second, if the employee does not work more than half of his or her time in any one state, then you need to consider whether the employee has a definite base of operations in California, in addition to performing at least some work in the state for the employer. If the answer is yes, then Section 226 applies. If the answer is no, then Section 226 does not apply. And the court did not address any additional considerations for employees who are neither localized nor have any established base of operations in any state. So all of which is to say, don't deal with employees who have work spread out through a bunch of states, because it's going to be really hard to know when the labor code provisions do or do not apply to them. But if you do represent them, you're going to have to figure it out, I guess.
Jody, can you
companion-
scroll your screen down?
Okay, yeah, sorry.
Thanks.
Okay, so that was the Ward case. Here's the Ward case. The next case is Amran. I'm sorry, not Amran, Oman. Oman versus Delta, 9 Cal 5th, 762. Here, a bunch of flight attendants brought a class action against Delta, alleging failure to pay its flight attendants at least minimum wage for all hours worked, and violation of Labor Code Section 226 and 204, which require at least semi-monthly payments of wages on a semi-monthly time frame. The Ninth Circuit asked the California Supreme Court to address three questions, and the court answered two of them. The first question, do Section 204 and 206 apply to wage payments and wage statements provided by an out-of-state employer to an employee who, in the relevant pay period, works in California only episodically and for less than a day at a time? Again, just note, this is talking about on any given pay period, so the analysis may change from one pay period to the next. Anyway, the answer that came back is maybe. As in the Ward case, the court analyzed what California connections were sufficient to trigger Section 204 and concluded that the principal place of work test articulated in the Ward case for purposes of Section 226 applied equally to Section 204. In other words, Labor Code Sections 206 and 204 do not apply to pay periods in which an employee works only episodically and for less than a day at a time in California, unless the employee works primarily in California during the pay period or does not work primarily in any state but has his or her base of operations in California. Question 2 for the Supremes. Does California minimum wage law apply to all work performed in California for an out-of-state employer by an employee who works in California only episodically and for less than a day at a time? And the court punted on that question. They said because of their answer to the question number 3, they are declining to settle the reach of California's minimum wage laws. Question 3 for the court was, does the Armenta Gonzalez line of cases bar an averaging of wages, or does the bar on wage averaging apply to a pay formula that generally awards credit for all hours on duty, but which in some situations resulting in higher pay does not award credit for all hours on duty? And the answer that came back from the California Supreme Court was no. This is rather lengthy, but I can't figure out any way to shorten it. So basically pursuant to published work rules with Delta, the flight attendant's pay was measured by the rotation by giving sequence of flights over a day or a period of days that the attendant would serve on. Compensation for each rotation was calculated according to 4 different formulas, and flight attendants were paid according to whichever formula yielded the largest amount for the complete rotation. the flight attendants, the plaintiffs argued that one of Delta's 4 formulas, which was the formula that most often determined how much the flight attendants were paid, violated the minimum wage law because it was based solely on flight time. It did not factor in hours that a flight attendant spent working on the ground before and after the flights. The attendants argued that based on Marta versus Amros, which was found at 135 Calab 4th 314, which holds that an employer may not take compensation contractually due for one set of hours and spread it over otherwise uncompensated hours or undercompensated hours to satisfy the minimum wage laws for all hours worked. This practice is commonly referred to as wage averaging, but for whatever reason, the Supreme Court decided that the better term is wage borrowing. In the Oman case, the court for the first time endorsed the rule against wage borrowing from the Amenta case. But even though they adopted the rule against wage borrowing, they then held that Delta's 4 formula method for calculating compensation did not violate this rule because the guaranteed flight attendants were always paid above the minimum wage for hours worked during each rotation without borrowing from compensation promised for other rotations. Under one of the 4 formulas, I think that's enough about this case. If you need more information, you're just going to have to read the case. It just goes on and on. But the key
Jody, not to
takeaway,
Jody, not to be a nudge, but can you scroll down again?
anyway, the key takeaways from the Ward and Oman cases are that wage statement requirements of Labor Code 226 apply to employees otherwise subject to collective bargaining, who are subject to the collective bargaining exemption found in Wage Order 9. So employers involved in interstate transportation need to reevaluate whether their wage statements under Section 226 and pay timing under Section 204 may be applicable to any of the members of their workforce based on the newly articulated principle of work test. And also employees with non-traditional compensation schemes need to take care to ensure that they don't violate the wage borrowing rule. And they need to pay special attention to the precise terms of their compensation plans, including minimum wage flaws that they might be built on. Okay, let's see. Next up, and my next case, it looks like I did not include this, and I apologize for that. The next case is a U.S. Supreme Court case, Our Lady of Guadalupe School versus Morrissey Beru, 140 SCT 2049 207 LED 2nd 870. In this case, the U.S. Supreme Court provided further guidance on the application of the ministerial exception, which provides religious organizations with a defense against generally applicable employment laws and the selection or retention of employees who perform certain tasks involving preaching, teaching, and counseling. In this case, 2 teachers were employed under nearly identical employment agreements that emphasized the Catholic faith as central to their work as teachers. One sued for age discrimination under the ADA, and the other sued for disability discrimination under Title VII. And both questioned both of these cases, the question was whether these employees were exempt from the statute because of the ministerial exception. The Ninth Circuit had ruled in favor of the employees based on the Supreme Court's decision in Hosanna Tabor Evangelical Lutheran Church and School versus EEOC, which was a 2012 case, 565 U.S. 171. That case recognized the ministerial exception for the first time. The Ninth Circuit concluded that the four factors outlined in the Hosanna Tabor case for the exception to apply were not present. The Supreme Court reversed the Ninth Circuit, holding that the ministerial exception barred courts from adjudicating either of the teachers' discrimination claims. The court explained that there was ample record evidence showing that both teachers performed religious duties, including educating the students about religion. Moreover, the court explained that there is no rigid formula for applying the ministerial exception, and that the Ninth Circuit had nevertheless improperly treated the Hosanna Tabor factors as rigid checklist. So the Morrissey Beru case seems designed to provide religious organizations with ample flexibility to choose their leaders and religious educators, and discourages courts from applying a rigid bright line rule or a multi-factor balancing test to determine whether the exception applies. Religious educational institutions, almost like who the teachers or the ministerial exception will most likely apply to their teachers that educate students on religious matters on behalf of the religious organizations. The next case is Conyer versus Hula Media Services. Now, this decision was depublished, but nevertheless, since review is granted, I'm going to go over it just so you know what the case is about. Eventually, I guess we'll have a decision from the Supreme Court. In this case, when Hula hired the plaintiff in 2017 and provided him with a copy of its employee handbook, which did not contain an arbitration clause. The plaintiff then signed a receipt and acknowledgement, and the employee had signed a receipt and acknowledgement to the handbook. In November 2017, Hula distributed a revised handbook, which now contained an arbitration provision. The plaintiff did receive the revised handbook and signed a receipt and acknowledgement. The plaintiff then sued Hula and the company's CEO for sexual harassment, failure to pay reimbursements, and other related claims. The defendants moved to compel arbitration under the November 2017 arbitration provision. The trial court denied the motion to compel, and the defendants appealed. The Court of Appeal reversed. The Court of Appeal held that Hula had no obligation to point out to the plaintiff that it added an arbitration provision to the November 2017 handbook. They applied the long-standing contracts rule in California that parties are bound by a contract, including an arbitration agreement, even if they do not read the contract before signing. The court also rejected plaintiff's contention that the agreement was unconscionable. While the court agreed that there was some procedural unconscionability because the employee handbook was a contract of adhesion, and Hula had the right to modify the agreement from time to time. It also held that Hula's failure to provide plaintiff with a copy of the applicable arbitration rules did not increase the level of procedural unconscionability. The court also found one provision of the agreement was substantively unconscionable because it required the parties to pay a pro rata share of the arbitrator's fees and costs, and allowed Hula to recover prevailing party attorney's fees. And the court just said, okay, well, we're excising that provision from the arbitration agreement, and they enforced it. I don't know, how much time have I spent? Have I used my time up yet?
6 hours and 22 minutes.
No, it just
Yeah.
feels that way.
I think we could switch to Marta now.
Okay, so let me get out of my, I got to get rid of this, I guess.
Marta, take it away.
So I'm going to provide y'all, lovely people, with a 2021 legislative update to review what California legislature and our voting legislators did in 2020, the dumpster fire of a year. So let's get going. AB 323, contingent workforce independent contractors. So this extends the exception of newspaper carriers from the ABC test, requires state agencies to give preference to local news organizations, specifically ethnic media and community organizations, in contracts and subcontracts for marketing and outreach advertising, and extends the newspaper carrier exemption from Dynamax for 2 additional years, allowing news outlets to stabilize from COVID-19 losses. We will see about that. Then another COVID-19 impact legislation is the AB 685, the COVID-19 notification statute, which is quite strict. If an employer receives a notice of potential exposure to COVID-19, the employer must provide written notice to all employees within 1 day. So right away. And it's also going to subcontracted employees who were on the premises, the same work site within infectious period. If the employer is notified of COVID-19 cases that is meeting the definition of outbreak, then the employer has 48 hours to notify the local public health agency. So don't forget to advise your clients that they have 1 day to notify their employees and subcontracted employees, so the employees of their subcontractors. Controversial legislation coming up, AB 929, the corporate boards diversity legislation, which is famed to be another questionably constitutional legislation requiring increased diversity on corporate boards. This, just like the requirement that female directors be placed on corporate boards, only applies to companies that are publicly traded and headquartered in California. Also, there is a funny definition of underrepresented community member directors, which includes directors who self-identify as Black, African American, Hispanic, Latino, Asian, Pacific Islander, Native American, Native Hawaiian, or Alaska Native, or who self-identify as gay, lesbian, bisexual, or transgender. So by December 31st, 2021, each publicly traded California headquartered corporation must have minimum 1 director from such communities, and then this increases in 22 depending on the size of not the corporation, but the board of the corporation. So depending on how many board members they have, the more and more these underrepresented minority directors they have to have, and the violations can result in hefty fines. AB 1281 is granting a 1-year extension, which was already granted to human resources professionals, usage of data from coverage under the CCPA, the California Consumer Privacy Act. However, employers are covered by the CCPA, and that requires employers to provide notice to job applicants and employees of what personal information we collect and what personal information and how we use that personal information. Marching on, AB 1512 and its partner, AB 2479. AB 1512 is basically overruling the Augustus decision and allows now employers to require that certain unionized security guards remain on premises and remain on call during their rest breaks. So if during the rest break, they are interrupted by being called upon to return to performing the active duties of the security officers post prior to the rest period. They are called on their walkie-talkie and they have to run back to continue monitoring or whatever circumstance that may be. They must be permitted to restart the rest period as soon as practicable. And if they have no opportunity to have that rest period, then the rest period premium pay will apply. So Augustus said that any employee who is at work, if they are on call, that means that they did not get their breaks, even if they are just on call and they are not called back. This statute kind of carves out that nuance that they only are required to be paid the premium pay if they are effectively losing their break. This is not a defense to any risk period violation claims filed before January 1, 2021, and it sunsets in 2027 unless extended. This statute comes from a companion statute, the Petroleum Facility Safety Sensitive Employees Rest Break Statute, which already allowed these employees who were unionized and working in safety sensitive positions at petroleum facilities to remain on premises and on call without getting a rest break premium. They may carry a walkie-talkie and respond to an emergency call, and then the same rules apply. So they are supposed to be allowed to receive that rest break whenever they can, and if they don't, then they are due that 1 hour extra hourly wage premium. So the sunset of this provision was extended to January 1, 2026. That's that statute. The unemployment insurance work sharing program was updated by AB 1731, which automates and makes creates an online portal in the EDD's work share program. And it is an alternative process to the paper process that is now available for employers to submit and be approved for a work share unemployment scheme, in which they basically are not going to get their reserves taxed if they are allowing their employees to participate in a work share program. So the detail is that the EDD must accept applications that are submitted electronically. You will see later that basically the electronic processing of documents is a huge issue in California because we have a very nuanced e-signature statute, and not every action can be carried out electronically. So this is one of these when there is a statute allowing document submission and document filling out to happen electronically, and it will be deemed just as if somebody affixed an ink signature to it. The EDD has to create a portal, online claims forms must be made available, and once this online packet is completed, then the EDD can open this unemployment insurance claim according to the statute specifications. So it's a nice little modernization statute that goes with our times when we don't want people to line up in offices, but rather to do things from their homes or their socially distanced workplaces. AB 1867 is another COVID related. There is so many COVID. I feel like basically everything can be somehow related back to the COVID pandemic. This is the supplemental paid sick leave, the hand washing and small employer family leave mediation statute. It feels like an omnibus statute. It had a lot of very divergent provisions, but the most relevant to us employment practitioners is the paid sick leave, which for the time being has expired, but this statute might come back if we have another federal legislation, such as the Families First Coronavirus Relief Act, FFCRA. So this created a corresponding state paid sick leave program. The same 80 hours of supplemental paid sick leave had to be provided. It created an allowance for hand washing breaks for food service employees to wash their hands every 30 minutes. And it created a small employer family leave mediation program by the DFEH, which requires employees to exhaust a mediation, a pre-litigation mediation with the DFEH before filing a case due to family law leave issues, I assume, under this statute. I don't know that detail. I have to look into that. That mediation provision sunsets in 2024. The supplemental paid sick leave expired December 31st because of the FFCRA failure to extend by our Congress. AB 1947 extends the statute of limitations for submitting a claim to the Labor Commissioner for Labor Code 11025 retaliation claims. The statute was 6 months, now it is 1 year. This goes hand in hand with California's march toward extending statutes of limitations, although it's not a requirement to exhaust this procedure. It is an alternative to filing suit, and the lawsuit, retaliation lawsuit, statute of limitation would be 3 years. So just to get it investigated by the Labor Commissioner, not have to go to court, that statute was extended to 1 year. AB 1963, as creating a new category of mandated child abuse reporters. Any human resources employee of a business with 5 or more employees that employs minors is a mandated reporter, and also an adult whose duties require direct contact with and supervision of minors is another mandated reporter. So they have to be given mandated reporting training and written statement, and if they do not report, then they are guilty of a misdemeanor. AB 2017 clarified that the employee decide whether the leave they take is paid sick leave to care for an ill family member, also known as kin care leave. The employers can no longer unilaterally designate the use of paid sick leave for any such leave. The employee has discretion to elect to be paid under this leave or take some other form of leave for it. It basically allows the employees to use other time off, or paid or unpaid, and reserve their sick leave for their own sicknesses. AB 2043 requires Cal OSHA to disseminate information on best practices for COVID-19 infection prevention in both English and Spanish. And I believe that they have done this already quite a while ago. The statute requires that the documentation they provide be easily understood by agricultural workers from a variety of ethnic and cultural backgrounds. They are also tasked with compiling and reporting findings related to COVID-19 investigations in agricultural workplaces. And they went into effect on September 28 and will expire when the state of emergency due to COVID will be terminated. The prohibition of no rehire clauses was again kind of clarified and expanded. So under prior law, the no rehire clauses are prohibited except where the employer has made a good faith determination that the former employee who made a claim against the employer engaged in sexual harassment or sexual assault. They added that if the former employee complainant engaged in any criminal conduct, then a no rehire clause may be added to the settlement agreement. But the employer has to have the documentation that they had this good faith determination of sexual assault, sexual harassment, and also the criminal conduct before the employee filed the claim. So a subsequent investigation that finds out sexual assault, sexual harassment, or criminal conduct cannot be used as a basis for a no rehire clause. And the employee must have filed their claim in good faith for this prohibition to come into play. AB 2231 lowered the threshold for qualifying as a public works project for purposes of the minimum wage provided at that project. So it redefined de minimis subsidy, and it's fairly technical. It is different for housing projects and general projects. Much more pertinent for our for the majority of our practices is the 2257 modified ABC test for independent contractors. So with this statute now, which is really complicated, there are now 109 categories of workers exempted from the ABC test in California. So the exemptions threaten to swallow the rule, or it just becomes so complex that nobody really knows. Even though considerable amounts of time, energy, and money were spent on lobbying by the trucking industry, the gig economy companies, and the motion picture TV industries, these were not included in the statute. But don't worry about the gig economy companies, because they got a little proposition passed, and so they got what they wanted. So let me just go back. It is AB 2257, and I can't even digest this. You have to just, each individual employer, each individual category needs to be assessed. There were certain musicians were now exempted, but not music teachers, for example, for one of the relevant situations in my practice. So as I said, there are now 109 categories. I started to kind of flesh it out, and it would take me days. AB 2399 is providing temporary disability insurance for military families. So the California Paid Family Leave Program, this is not really employment law, this is a wage replacement law, but as we advise HR professionals, they have to advise employees about the availability of this partial wage replacement benefit. So I thought to include this. So paid family leave provides partial wage replacement in case of having to take time off to care for a child, spouse, parent, domestic partner, or to baby bond. This was expanded to assist employees who have to be assisting a family member with being deployed, or whose family member is on active duty. So now we have the military member expanded to include child, spouse, domestic partner, or parent of the employee where the military member is on covered active duty or is called to active duty in the armed forces. And there is an expanded documentation allowed under this statute. So more different documentation may be used to show the requirement for this leave. My apologies. The COVID-19 PPE, now we all know what PPE is, personal protective equipment statutes piled up this year. So when there is one statute that requires acute care hospitals to have a certain amount of PPE supplies on hand for those employees who provide direct patient care and to ensure that employees use the PPE. So they have to maintain at least a 3-month supply of PPE and provide that inventory to the OSHA, CalOSHA upon request. And they have to make sure that this equipment is used. Also, acute care hospitals must reimburse employer-provided or employer-required training expenses of employees and job applicants, including residencies, orientations, or competency validations. This does not cover license requirements, registration, certification necessary to legally practice whatever the healthcare worker would be practicing at the job, or any education or training that is voluntarily undertaken by the employee or applicant at their sole discretion. The importance of this statute is that it prohibits those employment contracts that we occasionally see that require the training costs to be paid back if an employee leaves employment. AB 2992 extended the domestic violence, sexual assault, or stalking victim leave to include leave for the victim of any crime that caused physical injury or mental injury with a threat of physical injury, so violent crime. And it also allows leave to be taken for family members of homicide victims. Employees are also allowed to take this leave regardless whether any conviction, charge, arrest has occurred in connection with the crime, and expands what kind of documentation could be accepted to verify that such crime has occurred. AB 3070 is a very interesting anti-discrimination statute that aims to eliminate bias in peremptory challenges. So apparently existing law, the Batson-Wheeler doctrine, is difficult to enforce in practice. So this statute codifies the Batson-Wheeler rules and prohibits the use of a peremptory challenge to remove a prospective juror based on race, ethnicity, etc., and establish a presumption that certain reasons for excluding jurors are improper proxies for racial or gender discrimination. There doesn't need to be a motion to be filed. It is enough to make an objection, and then the court is required to evaluate the reasons given for the peremptory challenge. If the court sustains the objection, the court has several possible avenues to go down on. They may start a new juris action, declare a mistrial at the request of the objecting party, seat the challenged juror, or provide another appropriate remedy, and do basically whatever they want, because this is including but not limited to. So there is conceivably some other remedy there that's not listed in any of these. So this applies to criminal cases as of January 1 next year, and civil cases January 1, 2026. AB 3364 clarifies that FEHA protects military status or veteran status as opposed to veteran and military status. So if you are a military personnel who is not yet a veteran, then you are protected. AB 3075 requires a party creating a new corporation to attest under penalty of perjury that they have no outstanding final judgments issued to them for wage and hour violations. This is a purported fix for the corporation crawl that employers sometimes try to avoid having to pay for wage and hour violations. They basically open up a new corporation under their brother-in-law's name and continue practicing the same unlawful practices as before. So this makes the successor employer liable for judgments against the predecessor employer and defines what is a successor employer. So if they use the substantially same facilities, substantially the same workforce, offer substantially the same services, has the substantially the same owners or managers, employ a managing agent or any person who was a managing agent, any person who was a managing agent for the predecessor employer, or operates a business in the same industry. Business has a principal who is an immediate family member, as I said, brother-in-law, of any principal of the predecessor employer. AB 3175 refined the sexual harassment training requirements for minor actor and entertainment employees. So these are minors who are between the ages of 14 and 17 who are required to attend a sexual harassment prevention training before they can obtain a permit to work in the entertainment industry. This statute clarifies that the minor must be accompanied by a parent or legal guardian during the training, and this parent or guardian must certify to the Labor Commissioner that the training has been completed and that a foreign language translation of this training must be available whenever reasonably possible. If there is any flexibility, the legislature will apply it. So there will be maybe or not a foreign language translation. AB 3372 allows any withholding notice document to change an employee's tax withholding allowances to be served by electronic transmission. This is the statute I referred to earlier, which clarifies that a revised W-4 submitted to HR by an email is acceptable to that HR to change the earnings withholdings. SB 275, again, a PPE statute, requires that specified healthcare employers who are not the acute care providers maintain an inventory of new and unexpired PPE sufficient to cover 1.5 months. So it's half of the prior statute, which required 3 months of surge consumption in the event of a declared state of emergency. So I think it is pro rata data reporting. My apologies. I think my spell check thought that it's pro data. So employers must submit to the DFEH a breakdown of wage information related to race, ethnicity, sex, gender for the prior calendar year. This applies only to private employers with 100 or more employees who are also required to file a federal EEO-1 report. And there are some other requirements in the statute regarding the use of this data for providing a report. SB 1159 is a COVID-19 statute that creates a rebuttable presumption that an employee contracted COVID-19 at work if they have tested positive or were diagnosed with COVID-19 within 14 days after working at the employee's place of employment. They clarify the place of employment doesn't include working from home. This statute covers firefighters, Department of Forestry and Fire Protection, peace officers, fire and rescue service coordinators, etc., without any further requirement. For other employees, the law only applies if there is an outbreak at the employee's specific place of employment. This is where the rubber meets the road. So an outbreak is defined if specified number of employees at a specified place of employment, which I simplified here as a location, test positive. So if you have 1 through 100 employees, but I guess 4 through 100 employees, then you have an outbreak if you have minimum 4 employees test positive. If it is over 101 employees at a location, 101 or over, then 4% of the number of employees who reported to that location has to test positive for COVID-19. Or an outbreak exists if the specific place of employment was ordered closed and yet the employees had to report. So if you were ordered closed and the employees report, then I guess any employee who is positive or diagnosed with COVID-19 can take advantage of this rebuttable presumption, and workers' compensation coverage will apply. The CFRA was expanded considerably. So it expanded the categories of family members, and the CFRA is now applicable to employers of 5 or more employees. Until now, this 12 weeks of unpaid CFRA leave, that is leave, okay, was available only to eligible employees who were employed at a location with 50 or more employees within a 75-mile radius. And there was a companion statute, the New Parent Leave Act, which lowered the threshold to 20 employees. This statute now expands the CFRA's coverage to 5 or more employees, repeals the New Parent Leave Act because it became obsolete, and eliminates the key employee exception. All eligible employees must be reinstated, and the eligibility requirements remain the same: 12 months or more of service and worked at least 1,250 hours during the previous 12 months to be eligible. SB 1384 allows the Labor Commissioner to represent indigent persons when wage claims are referred to arbitration. So basically it closes the loophole that an arbitration agreement would provide, in which case the wage claim would have to proceed to arbitration, but the Labor Commissioner would not be able to represent the claimant. So Labor Commissioner representation applies if claimant requests it, claimant is financially unable to afford the representation on their own, and the Labor Commissioner determines that the claim has merit based on an initial investigation. I guess we shall see. And now to the propositions. We have 2 here to talk about. The Proposition 22, the Uber Lyft proposition, which passed by about 58% of the votes. So I think it's quite a majority. I thought it would be much narrower. App-based drivers and drivers are now independent contractors and not employees. So app-based drivers are those who provide delivery services on an on-demand basis through a business's online-enabled application or platform, or use a personal vehicle to provide prearranged transportation services for compensation via a business's online-enabled application or platform. The ballot measure does not apply to any other types of workers and requires these businesses that have the online enabled application or platform to comply with certain minimum benefits for these contractors. So they have to pay some minimum payments if business is too slow, limiting the time that an independent contractor can work to 12 hours and requiring 6 hours rest breaks between their shifts. Specified healthcare subsidies need to be paid. Occupational and accident insurance need to be contributed to a specified percentage. Short-term disability payments must be provided, and accidental death insurance must be provided for employees, independent contractors who suffer an accidental death while they provide these app-based services. Proposition 24 expanded the consumer privacy rights. So this is basically expanding on the prior statute that I've read about. Existing consumer privacy rights under the CCCPA were expanded and some new rights were created, and the ability for businesses to fix violations before being penalized was eliminated. Consumers may prevent businesses from sharing personal information. They may require the business to correct inaccurate personal information, and they may limit the business's use of sensitive personal information, which is precise geolocation, race, ethnicity, religion, genetic data, private communication, sexual orientation, and specified health information. This proposition established the California Privacy Protection Agency to additionally enforce and implement consumer privacy laws and impose fines, authorizes civil penalties, and triple civil penalties if the consumer affected is less than 16 years old. Changes which businesses are required to meet requirements of the CCPA, and prohibits businesses from retaining personal information from longer than reasonably necessary, again, a flexible term. Extends the exemption for human resources personal information from many of the CCPA protections until January 1, 2023. But again, the pre-collection notice requirement was reaffirmed. That was my presentation. I usually have a slide that says questions. I love questions. So let me know.
So far, no questions in the chat.
I see a corporation can have an all-male or all-female board of directors, and that's just fine. The corporation can have an all-female board of directors if it is publicly traded corporation. And as of December 2021, I guess, they have to have one of those female members of the board if they are publicly traded, be also a member of another minority. And an all-male board of directors, if you are publicly traded, is not just fine.
Okay. So Daniel Payne wants to know why all these sunset provisions are put into the statutes.
Well, that is an interesting question, and let me go into legislative nerd. The wisdom of the legislation is questionable, so the opposition party only agrees to pass the legislation if there is a sunset to reevaluate at a later point if the legislation bore the result that the proponents advocated in various hearings that it will bear. The idea is that when it sunsets, it just disappears from the statute books, and the prior form of the statute will magically come into being. What happens typically is that it gets extended a couple of times, and if it constantly gets extended, then eventually the sunset gets removed because it turns out that it was a good and worthy legislation, or just the majority is sufficient to pass it as such. So there is another question about this gender that just came to me. So the list of minorities doesn't include gender because there was a requirement under a separate statute some 2 years prior that a female director must be placed on publicly traded boards. So now, in addition to a female, these other minorities also need to be placed on the board. These are the underrepresented minorities, so not all minority status. I, for example, do not see certain Middle Eastern minorities listed there, which was the question I got from my client. So I stared at it and I was thinking, well, that's interesting. So gender is covered under one section of the code, and other coexisting minorities are covered under this other. So now there has to be a female and a otherwise underrepresented minority. I don't see the statutes mentioning that this could be both, like a female who is a Black female would satisfy both of these statutes. To me, it stands to reason, but whatever. Let's see what I can see here. Do you see anything else?
Nope.
Well, that just means I was awesome because I was explaining everything so well, right?
I guess so. So unless there are no further questions to either of the panelists, we'll say thank you for coming and goodbye.
We will send out these materials ASAP.
Yes.
And had as non-union employees. Okay, there is a question about non-union employees in security, but so it's not even all unionized employees. The requirement is that they have to be covered by a collective bargaining agreement, and they have to have a certain minimum wage that is above a threshold, and then they are covered by this rest break exception. So non-union employees in security and petroleum are supposed to be provided an uninterrupted off-duty rest break, and if they cannot finish their rest break because they have to resume their duties, or if they are required to even carry a walkie, I think that's the idea. If they are required to be carrying a walkie and be able to be recalled, then that's not a rest break at all. So in the healthcare context, if you are in healthcare, you carry a pager and you are basically on call all the time, and you may or may not be taking your rest breaks, and that's kind of the job, and it comes with like an enhanced compensation typically. But in any other jobs, if you have a break that's not really a break, if you have to carry a pager, carry a walkie, and be listening to it, and sleep with one eye open, is how one court put it, or just be on alert for your pager buzzing or your walkie talking to you, then you don't get a rest break, and every day you have to get that 1 day 1 hour a day penalty premium pay paid to you. Lovely case when it gets to you, because these penalties stack up really nicely. Well, thank you everyone for the thank yous. I thank you for listening, and I wish you a much better 2021. And back to you.